Right here, this year, sorry. We go into our other room? And I don't know, sorry, I'm sitting. I should have.
Yeah, I felt bad. I was like, ah, crap, you know? Because I've done it twice, and both times you're like, you know.
No, I don't, I know away from me. I know it's a big one. I didn't do it. I didn't really, because I was.
No, if I was in your situation, I would. Yeah.
Why else would I feel good? Still up, still up.
Morning.
Don't start it, Linda. What?
Why do I feel good?
You have other interpreter cases in here.
Tell me.
No, it's killing you, isn't it? What is?
I'm just thinking, what happened? You know, my husband's been working from home.
Well, I look at it,
Garage, it's just
you know what I do?
I'm gonna go find that case. Okay. You already told me.
3 months ago.
Oh, what case? It's not here with the other one? Oh,
Didn't he quit from an NGO?
Manuel.
oh, he was trying to, but he decided to.
Yeah.
Because he likes to smoke.
Yeah.
So he's in the garage.
So-
And now that it's colder.
Well,
I
under
mean,
circumstances, sure.
Before, I mean,
You
the
walk in
time
there.
to appeal this file, comparing
Well,
the file
yesterday,
to motion
I,
to stay the
went in there to
sentence.
grab some water
And I
from my
was
fridge.
just, it's not
bring to
clear
work.
in the docket notes if the
And then
order
I
was
came
granted
and
by
I
Judge
walked in
Stillwell
there.
or not.
You're gonna wanna maybe talk to the clerks, cause they can
Read it.
actually hold them on
What's
The file?
the actual court file
Okay.
And I'm just like,
and see.
well, it's like, she goes, it smells like cigarette. And I said, oh, it's probably me because, you know, my
I'm
husband's
doing it for myself right
smoking
now.
in the garage, and I went in the garage and grabbed some water. And I said, and you know how your clothes absorb it.
So I've got ready to go, I don't have to think about it.
And they're like, oh, no. And then they said,
If
"No,
it
I
hasn't
don't
been
think
stayed,
it's
he's
you." I
almost
go, it has
done.
to be. She
Okay.
just smelled it.
Do you know if the file's up here? It is, can I look
So
at it?
that's why.
Linda,
Huh?
can you help them with one of the court files?
Sure.
Can I see Nicholas Manuel?
Yeah, help him, because he looks like he's lost. He's going.
Even more than usual. Where am I? What's going on? Who are you?
Hey there, we haven't done any
Yes,
EYs for 20.
But I can't tell if it's been stayed or not. And then we're closing sentence for the 30
Okay,
minutes.
what number am I on?
Then, I'm not sure what we're doing.
If it's already been imposed, why are we imposing it again?
Right, well, it would only make sense to have it stay pending appeal. Hopefully it hasn't.
Okay, we're gonna change to 21, so it'll be 21-001. Will be the new one that I'm gonna do right now, so I'll bring it back and show you later, but I just wanna make sure you hadn't done anyone for 20.
How far are you on?
I'll be 5 months next week,
Okay.
about there.
Dang.
Right, PPA by 21.
I got a long ways to go, but I look like I'm
Okay.
7.
Perfect.
I'm done. My feet are sore, I gotta call my
They'll
doctor.
take them and put them in there, that'll be fine.
Chad's
So,
making
all right,
fun of
thank
me
you.
this morning, he's like, it's too early for you to walk with this. I was like, if you only knew, my sciatic is killing me. My feet are swollen. I ain't 20.
You what?
I was like, I ain't 20 years old. He's over here making fun of me.
If something-
He's like, it's too early for you to walk like that. I was like, if you only knew.
Waddles?
Yes, but it's my sciatic.
I wonder if can you tell us where compression starts?
Okay. So, are you guys just
Go ahead. You-
The only thing I see in here is this unsigned motion in order to stay sentence.
Okay, did your client report?
Oh, shoot, I have no idea.
Well, that's gonna be the next thing. is
Well-
Either it was stayed and he didn't report, or it didn't get stayed. And
Right.
he should have, I don't know
He
what
should have
jail sentence
reported.
was, or
I have
anything
no
like that,
idea.
so.
I was only on the appeal, so
Okay.
I don't know. But,
Interesting, all right, well,
if it has not been stayed, there are like 3 months left, of probation.
right, but he's going to get warrants today.
You're gonna hammer
He's gonna get a
him.
warrant
How's
today
the
for
time?
showing up, right?
You got 3 months to hammer him. But I think he did check in like a few months, like a year ago, at least.
So we're good?
I'm ready.
Yes, if you have the right plan.
You're ready?
I'm
You
ready.
don't need one, but,
Are you the provisional today?
No, oh no, I'm just writing
Okay.
on Nicholas Manuel. I
no,
just
I don't
have,
need it, I've got it.
yeah, Manuel.
I got it figured out, so.
when is the judge coming out?
Give me just one second.
Let me, ask the prosecutor if they're ready.
Okay.
We're not ready on the custodies.
No, I'm not asking
Yeah.
that.
Not ready on any custody?
No.
Are we doing
No.
to start the, 8:45 docket?
I am the 8:45 docket.
Okay, yeah, so
Oh.
we have other attorneys too that are on the docket, Mr. Scott.
All right, well,
So we'll wait for Attorney Roach so that we can.
all right.
It was fine, but I made a copy.
I'll,
Okay, yeah,
for you.
let me call the judge.
DOC violation.
okay. What? No, that never happens.
Hi, Judge. It's Linda.
I'll read it, just a second.
Attorney Scott is ready, but Attorney Roach is speaking with his client, so.
Yeah.
Well, did you,
I don't know. if
did you
want
come
to-
out unscathed,
Copy
Mr.
of
Scott?
the DOC report.
Unscathed? From what?
Thank you,
From
Mark.
You're welcome, thank you.
DC, and you.
Yeah, that's right. Well, I was wearing a mask, so no one will know it was me.
Okay, I'm in here.
I was one of the people in Nancy Pelosi's
Okay, well,
office.
the judge is gonna come in and,
I'm surprised that you didn't call that guy, Mr. Scott.
Didn't call
The
me.
guy sitting behind Nancy Goldie's desk who said he needed a good attorney. Did you not see that?
Well, that'd be soliciting business. Otherwise, I.
No, he asked for it. He said,
That's
oh, me,
true.
he said, I'm gonna need one.
And I think he's right.
I think he's right too.
I don't think he has any idea.
It's almost.
I mean, you can blow up Target and you can loot and set things on fire and do whatever you want, but when it comes to the actual lawmakers, you better watch out.
Right? You can tear somebody's business down, terrorize them in their own place of work, and that's fine. But if
That's
you
social
terrorize them
justice.
in their place of work, it's
Right.
treason.
All of a sudden, right?
Right, all of a sudden, that's the part. And then did you see yesterday, there was all the stuff that happened in Seattle with the brand new federal courthouse, they just fixed it, and they went back up, broke the windows, and all the lawmakers were like, hey, that's good.
Yep.
As long as it's not a
Good for them.
Capitol building,
Good for them.
Take a whole city block.
I
right?
mean, judges, lawmakers, there's a huge difference there.
What
Like, what? People
was
whose
it,
life
the
work.
mayor in Olympia, or what was it, the guy in Olympia that he was all for it, and then all of a sudden they came to his house and destroyed his yard or something, and then he was like, oh, this has gotta end.
I think
Right?
the Portland mayor was like that for a while.
No, this
Yeah.
was in Olympia.
The Portland
Portland mayor
mayor,
got punched the other day while he was eating out,
who did?
Wheeler,
Wheeler, oh, really?
so,
And he was there marching for them at one point.
right?
Oh, this is a crazy world we live in. This is the craziest time.
Yeah. When I retire, I'm gonna sell everything and buy a place up in the woods. and
Go
just-
to Ruby Ridge.
Yeah. I don't wanna go to Ruby Ridge. You know, my wife's Hispanic, you know. I'll let her keep her around for a minute.
Pull that forward out of there.
Well, they did run out the white
Yeah,
supremacists
I
up
know.
there pretty well, I guess.
Sorry, that was.
They don't have the presence they used to
Right.
in northern Idaho. Yeah, that's not what I was saying.
It's actually.
I wasn't saying join the KKK. I was saying just get out of society. Or actually, I think it was neo-Nazis that used to be
Yeah.
there. Yeah.
Which, to them, I'm worse than my wife.
Right.
She doesn't have a choice.
Right.
She is.
Yeah.
I made a choice to get down with the Browns.
Pull it up from underneath.
Todd knows what I'm talking about.
Pull it this way.
Yeah, we've been through that. We go to Coeur d'Alene, to the resort there, and we've experienced,
Have you?
Oh, yeah.
Really? In Coeur d'Alene?
yeah, at the resort,
Oh,
in
that's
that
terrible.
small town there. Yeah.
Oh, Hayden. Right, Hayden is right by Coeur
Yeah.
d'Alene, right? And that's where they were.
I
mean,
I don't like to go there, but he likes to go.
well, Coeur d'Alene
I
is
don't go
beautiful.
anymore.
It is beautiful. But how long ago was that?
Maybe about 3 or 4 years.
Really? Oh my gosh.
Yeah,
I
we go
can't
golf
believe
there,
that.
and
I'm really
we've had
surprised.
some bad things happen.
That's awful. I do remember going into Walmart thinking, this is the whitest Walmart I've ever seen. Coeur d'Alene. That's like, holy cow.
It's so white that as a white man, I feel uncomfortable.
Yeah. Like, something's not right here. It's not the Walmart I'm used to.
That little brown pigment to me, I might be in trouble. What I found interesting is some of those pictures, the people were almost in costumes and stuff, and some supporters don't do that. So it's almost like they were trying to make it look clownish.
Right.
To me, I think BBC leads on some sort of like a sharp frenzy.
Oh, for sure.
I think there was people.
Which one has what?
Take a look at it.
Yesterday,
I-
I heard that talking about that they wanted to buy people and they were.
It was the
Right, you know, a lot of people are talking like that conspiracy theory or whatever.
I
but
don't
it's-
know.
You know,
I
those options are not mutually
Because
exclusive.
Judge said
You
it was
can have
Right.
consequences in there, you can have
Yesterday,
agitators in there, and I think that's what
He
happened.
was supposed to be right up today.
Not certain, I think that's likely, so.
Rita, which one's probation?
What, I think it-
You had one for probation?
Yes,
doesn't matter.
this top one, and then Matt.
Where the anarchists got in there, they sabotaged it.
This one is.
This is theirs. Oh, okay.
So that's the
So it
one
was
she
Alvarez
wants me to
and
read all this on, I just haven't had a chance yet.
Okay.
Would you pass me the box of mine?
Not the media, not the politicians.
No.
He's
It is
thinking
really
the
funny.
Leons and
All rise, Mr. Court's now in session, Craig Stillwell presiding.
Morning. Seated.
Good morning, Your Honor.
Good morning. All right, this is Pasco Municipal Court. Today is January 8th, 2020. My name is Judge Craig Stillwell. We're here for a couple of different matters today. We have several in custody. We have a remote hearing scheduled at 10 o'clock and then some pre-trial and motions set today as well. Mr. Scott,
Yes, Your Honor, I'm just here for Nicholas Manuel, which is on for, it indicates imposition of sentence following remand of an appeal. And he's not here today, but what I gleaned from reviewing the file is that sentence was never stayed, and so I'm not sure if it's necessary to impose sentence.
Mr. Rio.
Well, Judge, I don't know if the court stayed the sentence, he needs to be here. If the court didn't stay the sentence, he still needs to be here. We're here to essentially re-go over everything after his appeal. And so the court sent him, I believe, notice to the court. This is certainly a hearing that can't go forward without the defendant.
I would indicate this, just on March 29th, 2019, is this the one where it followed a revocation of an SOC?
Yes,
Yes.
sir.
Okay. Sentence was imposed on that date, no jail time, fines and costs were waived, but he was placed on probation for 2 years. I think it is important that he be present. Let me take a look here and see. On the 29th of April, there was a motion in order to stay enforcement judgment pending appeal.
And my review of the file, Your Honor, indicated that that was not signed by the court.
The remand was done on December 16th. We scheduled this today's date. I think it is important. Did you handle the appeal?
I did, Your Honor. Yes, that's why I'm
All right.
here. And I think it would make sense maybe to put this on the probation docket, because as far as I'm concerned, I was just appointed for the appeal,
Yes.
and now it's a probation matter.
And I guess and I'm certainly not inquiring as to any conversations you had with Mr. Manuel. We did send notice on December 22nd for today's hearing. Have you had any contact with him since the appeal was remanded, or since the order of remand?
I haven't, Your Honor, not since the decision even. My contact information wasn't good, and he kind of fell off the face as well. Let me put it differently, I haven't heard from him.
All right, and the only address we have currently is the Pinehurst address.
And note that your notice was not returned.
Notice was not returned. He does have an address on West First Place in Kennewick listed with the Department of Licensing that was effective on June 11th, 2019. I want to note the defendant's failure to appear effectively. However, I think his sentence has been imposed. I mean, there's no jail time to serve. There's no fines and costs. The only thing he needs to be aware is with this remand, his probation continues. And if the matter was never stayed, I suppose it's been running since the time of the sentence. And I don't have any notice of probation of violations. So I'm going to note his failure to appear, and I guess my question would be this: is this a hearing at which he's a mandatory appearance, or is it sufficient that Mr. Scott is present today? Because the sentence was never stayed.
Right, we're here to impose sentence and it's already been imposed, so I would ask to just strike the hearing. And if there are any probation issues.
There is a probation issue, so we need to set it. He's got to do DUI, do ignition interlock. The problem is, I think it's a necessary hearing for him to be here because of the court is reimposing the sentence. I mean, it's the kind of thing where it's out there, but he's the one that removed it from this court. to say he doesn't need to be here when it then lands back in the court, I think is problematic. So I'm not asking for a warrant today, but he needs to be here.
And I think
So
under
we
the
can move forward.
circumstances, it is a little bit hazy. Mr. Scott was appointed for the purposes of the appeal. I'm going to note that defendants failed to appear today. We'll reset this, and I think we can move it back to even a Tuesday morning. I think Mr. Rio would be appropriate, because I don't see a huge argument about this coming up. Sentence was already imposed. It's just he needs to be made aware that he now has to comply with the probation department if that hasn't been made clear.
And we need to address the new violations.
Yes. So let's reset this to a Tuesday docket in 30 days or so.
That'd be fine.
And since today was just to impose the sentence, and since the sentence is already in effect, can I be removed from the case, Your Honor?
I'll make a notation that your responsibility as the appellate attorney terminates with today's hearing.
Okay, thank you, Your Honor. And so it's just a matter of the probation, Office of Public Defense.
When, yes, we'll address at the next Tuesday docket, should he appear, that we received the remand, the sentence was never stayed. Obviously, there's no time to serve or penalties to impose, but he is required to get in touch, and we'll start him back on that phase, and we'll probably serve him with a notice or a summons for the probation violation at that time as well.
Okay, sounds good to me, Your Honor. Thank you.
Right, thank you, Mr. Scott.
Thank you.
What's the new court date, Judge?
February 9th?
Thank you.
Okay.
I have to send notice.
Yes. You can go ahead and call Francisco Delgado as well.
Three pieces in the same paper.
Mr. Green, is there anybody in the hallway, do you know?
I will check.
All right, thank you. I'm having Mr. Green check the hallway for Mr. Delgado. I highly doubt that Mr. Delgado is going to be present. He was arrested.
There's no one in the hall.
Thank you. He was arrested yesterday or the night before on a DOC probation violation. He was held in Franklin County. He was seen yesterday apparently regarding that. Even though there is an outstanding warrant for his arrest for failing to appear for the arraignment on the driving license suspended ignition interlock charges, he has been released. We're here today based on the defendant's request to reset a motion that was scheduled on November 20th. It was his motion to address the judgment and sentence. He phoned on the 19th of November indicating he was ill, was not going to be able to be present at the hearing, and requested the matter be reset. He was provided notice of today's date. Mr. Delgado is not present. This matter was scheduled for 8:45 this morning. It is now 9:28. Because this was his motion,
He sees motion to strike.
I am going to strike the hearing today. But I'm also going to indicate that a probation violation has been filed yesterday. He's in non-compliance with his treatment. He's refused to attend. He's refused to attend the DUI Victims Impact Panel, although based on my review of the record, I'm inclined to give him credit for that because he attended that in June 2019, during which time he had entered a deferred prosecution in this case. Also, there are subsequent pending charges of driving without a license, driving without an ignition interlock device, a negligent driving, driving without insurance, and violation of his restricted license, all which are violations of judicial probation. I'm gonna issue a bench warrant in this case and set bail in the amount of $25,000 cash or bond.
How much was it first?
$25,000 cash or bond. So that'll go along with the warrant that was issued in the case on which he failed to appear for the arraignment.
And that will be for a PV.
That's for the probation violation, yes.
PV warrant.
Mr. Roach, excuse me, I was just looking at, Mr. Roach has some cases on here, but Mr. Rio, we do have one set, Shelley Oglesby, who's set for a compliance hearing, I think, and she's requested a remote hearing because she resides outside of state. Just for the court's edification, she's paid the costs, but I noticed that there was a requirement that she attend mental health assessment and follow the recommendation and have no alcohol-related offenses. Do you know if there are issues with compliance?
I don't have any knowledge, I don't have anything in my file that suggests compliance, but that,
So we'll need to call that and address that with Ms. Oglesby. Okay. I just thought if she was in fact in compliance, we could dispense and just notify her of the result. But we are scheduling 10 o'clock, so we'll hold off on that one. Well, Mr. Roach, yeah, he's ready to go.
Well, he was in the little conference room there.
We don't have anyone for Betty in there. No.
All right, Mr. Roach, are we ready on either of your?
We are, Judge. Actually, if you want to call Carmen Leone first.
All right, Jose Ramirez Leon, I don't have that.
Your Honor, he's not present, and that's a problem. But I'll at least give you the information that I have. Jose, I think, went to warrant status at some point after his revocation of this deferred, and then contacted the court, somehow got back into compliance with regard to a new court date. My recollection is that he appeared in court with Mr. Jones present, because I was up in Walla Walla, and they set it for today to sentence him on the revoked deferred.
Actually, I believe it's actually to address the revocation. I'm not certain that it was actually revoked.
Oh, okay. And that's fine. We're not contesting revocation. We know that he, Your Honor had a hearing on that, basically. We went through his last chance agreement. He had a last chance, and then he kind of blew it. It's real sad to me, but maybe predictable given his age and what we did with the case. So, but he called my office the day before yesterday, and again, I think yesterday morning, and he's sick, and he has not gotten a coronavirus test. My staff asked him if he was anticipating getting a coronavirus test, and he said, well, I don't know, because I don't feel that bad, but I'm sick. And that was the end of it. I didn't tell him be here anyway, because I kind of was frozen with indecision when I heard that information. I didn't really know what to do.
In most of these situations, I been erring on the side of caution
I appreciate
with
it.
regard to those. So I'll make a note that he's failed to appear today, that he did contact council, indicating that he was sick. Are you asking to reset this?
Yeah, I think just a couple of weeks maybe. If he's sick and he clears up, you know, he should clear up if he's currently showing symptoms and he gets diagnosed with coronavirus. He specifically talked about a sore throat and a cold-like symptom. That's how he described it. But so that didn't sound exactly like coronavirus to me. But I think it does all sorts of weird things. So yeah, 2 weeks if you could, just on a regular Friday. I don't care. The sentence in this thing is absolutely not what he's trying to avoid.
Well, I'll just note for the record, he has a new ignition interlock and UWS 2. So I have some problems. We have an FTA history.
Where are those out of?
Benton County.
I didn't even honestly know about that. But nonetheless, I guess I'd ask that we reset it and not issue a
And
warrant.
that's fine. I don't,
Yeah,
but I'm
The sentence
going to want to
in the
address
recommendation, I
those
get
things when he does appear.
I totally understand that. And I did not know about that, Jim.
Well, I vote to the 22nd, and of course, Mr. Roach, if you receive information from your client that he did get tested and he is in fact, will reset that.
Yeah, I'll let you know and I can represent to the court what we found out.
So we'll reset this to the 22nd at your request. That's without any written notice of Mr. Roach.
No problem. That's a great day, by the way. I have nothing on my calendar on the 22nd. How is that possible?
Anytime we could be accommodated.
Yes, thank you all.
Yes.
And speaking of accommodation, if I could call the next case, please, Your Honor.
Yes.
Higadera, and he's present. And I'm going to hand up 2 documents here, Your Honor. Oh, it is, okay. Judge, what the city has agreed to do in lieu of trying to set another trial date in this case is they've offered to dismiss the DUI. In exchange for that, we've handed up a new complaint alleging negligent driving in the first degree. I have gone over, actually, I think I failed to put the cause number and the date of incident in the form.
I have.
Okay, I apologize, Judge. I was going over that form with him without the benefit of his file in front of me in the back room with the interpreter.
And if I recall, and it does indicate in the complaint that this was November 25, 2018. Do I have your permission to?
Yes, please, I'm sorry about that. And so we've got a statement of defendant on plea of guilty that we've handed up, Judge. We'd ask that you accept that and adopt the recommendations of the prosecutor's office.
All right, with regard to cause number 8Z1114512, the city, I think, is making a motion to dismiss that. Okay, and so I will dismiss that original charge of driving under the influence. And I will need a judgment and sentence, but there's a new cause number,
And what is that?
which is the PPAY 21100.
Okay, and on the one that was just dismissed, there is $1,000 cash bail on
All
it.
right, we'll address that.
There's also the infraction.
Yes. An insurance violation.
He's got, we could prove that up at some point. He's got insurance on about 20 vehicles.
Judge, and what was the charge?
The new charge is negligent driving refers to.
But for this, it hadn't covered this time. We'll get that. After agent, if you don't mind.
Right, Mr. Higuereta, you're here today on a charge of negligent driving in the first degree. That is a misdemeanor. It's punishable by up to 90 days in jail and a $1,000 fine. There is no mandatory minimum sentence for such a conviction. Do you understand that, sir?
Yes.
You do have a number of constitutional rights as a result of this charge. Those rights are contained in this statement of defendant on plea of guilty. On this statement, there are some initials placed here. Did you place those initials here? And specifically, did you place those initials to indicate that you've gone over these rights that are listed on the back of this form, as well as the potential consequences and the potential immigration consequences if you were to plead guilty today? Have you had a sufficient amount of time to talk to Mr. Roach about this case and the rights you are giving up by pleading guilty today? Would you like me to go over those rights with you again? There's a signature on this document as well. Did you place your signature on this document? And was that to indicate that you have reviewed the case with Mr. Roach, you understand the charges against you, that you are making a plea to this charge today and you're doing this voluntarily? Other than the recommendation, has anybody made any promises or threats to get you to plead guilty today? To the charge of negligent driving in the first degree, a crime which was committed on or about November 25, 2018 in the city of Pasco. How do you plead, sir? Guilty or not guilty? Your statement is that on or about that date in Pasco, Washington, I operated a vehicle in Pasco negligently while showing effects of an alcohol consumption. Is that a correct statement?
Yeah.
And Mr. Roach, in order to establish the elements of the negligent driving, is it sufficient that I incorporate the affidavit of probable cause from cause number AZ-11145?
Yes, Your Honor. What I'll also say for the record is that this charge was originally charged as driving under the influence. You know, the incident date bore a charge of driving under the influence. Shortly before the trial date, it was by witness identification determined that Mr. Higuereta did not drive the vehicle into this crash site, but that the second theory of the city's case was that he was in physical control of that vehicle at some point afterwards and attempting to drive or move it from the crash, you know, move it off the tree that it was crashed into. And that was the theory of how they could potentially prove physical control or, you know, attempted DUI. And so as a consequence, we agreed to this disposition to avoid the potential of a conviction of a greater offensive trial.
And Judge, we did have a witness who heard the crash. By the time that they saw this, they saw him outside the vehicle, saw him climb back in, which the car's now off the roadway. And it would have been an interesting question of whether it was safely off the roadway, but we think this is a good resolution based on what the witness saw. So.
And even based on the recitation of those facts, if those are contained in the affidavit of cause, that sounds like there's sufficient basis for a negligent driving.
Sure. Yes. Correct.
All right. Based on that, I will accept your plea of guilty and find a factual basis for this charge of negligent driving in the first degree. You do have a right to address the court before any sentencing. Mr. Roach, is there anything you would like to say?
Judge, as you can tell, we've gone through some extraordinary efforts here to defend this case. And the truth is that he didn't drive his vehicle, you know, intoxicated and get into a crash. That's the truth. But there is a way that they could have proved this other alternative theory that, you know, involves some risk on our part. But the reason why I point that out is not to have a protestable guilty plea, but rather to describe or quality about this particular defendant that resonates throughout his entire professional life, and that is that he's a man of responsibility. He had a driver this night. He knew he was drinking. It went bad, no doubt. But he is a very, very successful business owner and has worked very, very hard since a very young age in his life. Quite frankly, at the risk of sounding too gooey and flattering, I truly look up to this individual to my left here as sort of a hero of this community. I don't say that for any other reason than I just truly actually believe that. So this is an embarrassment. It's unfortunate. I have zero reason to believe that he's going to be anything less than perfectly cooperative with whatever you sentence him to. He'll pay all of his fines. He'll get this behind him. And you'll probably see his name and hear about him in a totally different context from this point forward that you'll be proud of as a member of Pasco's community here and the greater community. So keep an eye out is all I'll say. And I think he'll gain he'll gain your respect over time, Judge.
Thank you, Mr. Roach. And Mr. Higuereta, you do have a right to address the court before any sentence is imposed. Is there anything that you would like to say? I don't see any reason not to follow the recommendation in this case. This appears to be the only blemish on your record, Mr. Higuereta. So I am going to follow the recommendation. 90 days in jail with all 90 days suspended. A fine in the amount of $854.50, a $43 criminal conviction fee, a $102.50 traffic penalty assessment. There is a probation fee of $200 and looks like an alcohol violator assessment of $250 and a DUI emergency response fund assessment of $300. That is a total of $1,750. There is bail that was posted in the prior 8Z 1114512 case. We will apply that bail. That leaves a balance of $750. Do you want to pay that or set up payments on that?
And we'll just take that little slip, Judge, of when he can, the earliest time he can pay, he'll get it paid.
All right.
Which may even be today, is that right? Are you your window open today?
Yes. It is.
You have to break the check.
So I'll say pay in full by February 8th.
Okay. I say that so casually. Yeah, no problem. Well, it's not my money.
And I'll specifically make a note here that apply the bail from that cause number. While on probation, sir, you're not to have any criminal violations or incidents. You're not to drive without a valid driver's license or insurance. You're not to have any alcohol-related infractions or offenses. Does this indicate an evaluation or just a victim's impact?
Evaluation.
And no alcohol.
You're not to possess or consume any alcohol, marijuana, or non-prescribed drugs. You're to have an evaluation for an alcohol drug addiction within the next 120 days and complete the DUI victims impact panel within 120 days as well. Mr. Higaretta, are you still on the West 35th Court address?
Yeah.
I will, yeah.
I'm leaving, I'm leaving sometimes, I'm staying in Pasco and other times in Kennewick. Is there a problem with?
No,
No, I just your mailing address in case you need any information for the court.
just for me.
You will be required to contact probation. We are scheduled for, or will schedule a telephonic hearing.
It'll be January 19th.
That'll be on January 19th. We'll give you the phone number. We're not doing in-person appearances right now, but we're treating those phone appointments as important as if you were appearing in person.
On these straight up neg one, please, there's not even a risk assessment done, is there, Judge? I can't
I don't
remember.
believe there is.
Not that he wouldn't pass it, if that's the criteria to pass fail.
The only other issue is the insurance.
So, Your Honor, I mean, I recognize the seriousness of that allegation, and I never try to, dink around with it or ask to get it dismissed if I don't have proof. I'm happy to put that on any other docket and get you proof that he had insurance. He owns, I mean, honestly, literally like a dozen or more vehicles. He's got a massive insurance policy.
Why don't we do this then, Mr. Roach, not to be rude or cut you off. Let's set it on a mitigation docket. And if he wants to, when he comes in to make the payment, bring proof of the insurance, he can provide that and indicate at the window he wants to address that so he doesn't have to. And then if in fact it is insurance, or even if it's obtained after the fact, or whatever the case, he can address it at the window.
He's got it from the data.
So we can,
But it's probably doesn't go back to 2018 or now, but it's usually like a 6-month window or a 12-month window, you know. If he didn't have insurance, he would have been paying a lot of money.
you want to do that? Set that on January 28th. Is that enough time to be able to? That's about
Absolutely.
3 weeks.
Absolutely.
And just so it's clear, Mr. Higaretta, if you come in before that date and you do show proof at the window, you won't have to return on that court date, okay? That hearing will be at 2:30.
I'll be there if they don't strike it ahead of time. We don't have to. You bring their insurance to the window when you make the payment. If you don't have something that goes back off, ask your agent just to write a quick letter saying he had insurance on that day. They'll do it.
And make sure the letter includes the vehicle that was involved in this and that he was a covered driver.
Thanks, John. Do you remember what a copy was? All right, Judge, thank you very much for your time.
All right, thank you, and you have a good day, Mr. Higaretta.
Let's go out in the hallway real quick.
No, we will take care of the custodies.
Okay, I will do that.
Angel Alvarez? Yeah. You just go ahead and stand where you are, Mr. Alvarez. Good morning. You're here today on, it looks like a probation violation. a hearing was scheduled for January 27th, but it looks like they determined you were in custody, so brought you down for this. You're here today on an allegation of a failure to comply with a treatment program. I only see one violation. Was there a subsequent?
Mr. Huey, I think, has all of the things that you needed to know.
Oh,
There's
yes.
multiple DOC violations for admitted cocaine use, alcohol, etc.
Yes, I have that subsequent amended notice that is failure to comply with the program and a number of alcohol or drug violations based on a report from the Department of Corrections. Mr. Alvarez, you had a chance to talk to Mr. Huey today, the provisional attorney, and he's indicating you are admitting those violations. Is that correct?
Yes.
All right. And did you discuss with Mr. Huey the recommendation from probation?
45 days.
45 days. Is there anything you would like to say regarding this violation, Mr. Alvarez?
No.
I am going to indicate here today, Mr. Alvarez, that you are admitting the violations
The city's recommending 45 days.
and that the recommendation is for 45 days. What's the issue here, Mr. Alvarez? Why aren't you complying with your treatment? I think it's required in more than just this case.
Yeah, I just get overwhelmed, I got probation and 2 courts, I got DOC, there's no excuse for my behavior, I make my own choices, and I guess my choices led me here today, and I have nothing else to say.
And you know what you might do, you indicate that you get overwhelmed, that their participation in the class might give you some tools that help you to deal with some of these things as well.
So the reason why I'm not in compliance for November and December is because I missed 2 classes each month. But I've been going to my support meetings. It's just, I don't know, I get these moments in life where I'm just like, I just want to throw it all away for some reason, and I go through with it, and I don't know why. I think it's just, I have no clue why.
Now, have you done a DOC hearing yet on?
On Tuesday, next Tuesday, I'll have a hearing to see if what's the recommendation for my DOSA revocation.
Okay. And has Mr. Alvarez been held on this since yesterday?
He was remanded yesterday, Your Honor.
I'm going to give you credit for 1 day served. That was a balance of 44 days. Mr. Alvarez, you are on probation on this. You indicated that there will be a hearing regarding your DOSA. If that's revoked, let probation department know here if they're sending you to the Department of Corrections, so we know the outcome of that, so we know how to proceed, okay? And you can do that by sending a kite down from the jail before you leave. I am going to indicate that I have no objection to this running concurrent with the DOC because it looks like that may be the issue. But you are maintained on probation. If they don't revoke your DOSA, you're required to report. You're required to get yourself into treatment and stay in compliance with that treatment. I can tell you, Mr. Alvarez, that that's going to be your best bet for getting over the issues that you have right now, okay?
Yeah.
All right, I have some paperwork here for you and we'll give you a copy of that. That concludes your hearing. Mr. Alvarez, you can have a seat, sir. I'm just curious, did they start Zoom this morning? Is any-
I don't see anybody. Let me get into the waiting room to ensure. There's a Galaxy A50 in the waiting room.
All right, that may be the individual who's waiting for us. So I don't know if you can communicate with that individual, but let them know that we are handling some other cases, to please stand by. Roberto Montalongo. Mr. Montalongo, if you'll stand there where you are, thank you. Good morning. You're here today on a charge of driving a license suspended in the 3rd degree. That is a misdemeanor. It's punishable by up to 90 days in jail and a $1,000 fine. There is no mandatory minimum sentence for such a conviction. Do you understand that, sir?
Yes, sir.
I have reviewed the affidavit of probable cause. I do find probable cause in this case. As a result of this charge, Mr. Montalongo, you do have a number of constitutional rights that were played in the conference room there before you came in. Were you able to hear and understand those
Yes, sir.
rights? Do you have any questions about those rights?
Okay.
You have had a chance to talk to the provisional attorney today, and after doing so, you did hand forward this statement of defendant on plea of guilty. There are some initials on this document. Did you place these initials here?
Yes.
And did you place those initials on this document to indicate that you understand the rights you have, you understand the potential consequences, as well as the potential immigration consequences
Yes,
for a plea today?
Yes, sir.
And there is a signature on this document as well. Did you sign this document?
Yes, sir.
And did you do that to indicate that you've discussed this case with Mr. Huey? You understand the facts of this case and you're entering this plea today voluntarily?
Yes, sir.
There's a recommendation contained under paragraph 6. Other than that recommendation, has anybody made any promises or threats to get you to plead guilty today?
No, sir.
To the charge of driving a license suspended in the 3rd degree, crime was committed on or about January 7th, 2021 in the city of Pasco. How do you plead, sir? Guilty or not guilty?
Guilty.
Your statement is that on or about that date in Pasco, Washington, I drove a car while my license was suspended in the 3rd degree. Is that a correct statement?
Yes, sir.
And for the record, did you read this statement or did Mr. Huey read it to you?
You read it to me.
Thank you. I'll accept your plea of guilty and find there's a factual basis for the plea. Mr. Montalongo, you do have a right to address the court before any sentence is imposed. Is there anything that you would like to say?
No, sir.
Are you working, Mr. Montalongo?
I'm not.
When was the last time you worked?
2 months ago.
And are you not working because of COVID or are there other issues?
Yeah, because of COVID, got laid off.
All right. Before that 2 month, or before the 2 months ago when you were employed, how long were you employed?
3 months.
And before that, was it again a COVID issues
I was in
that?
prison.
Prison?
Yeah.
All right. Mr. Montalongo, looking at your history, I do have some reference with regard to your, excuse me, legal financial obligations. Looks like they have accumulated something over $15,000 or more. So based on that, I'm not going to impose any fines or costs in this case. Give you 1 day in jail, credit for 1 day already served. Mr. Montalongo, you did receive, along with this criminal charge, some civil infractions. I'm going to dismiss the defective brakes and the unlawful display of the license plate, but there is an insurance violation as well. Typically, you would be required to respond to those infractions by either paying the amount of the penalty or requesting a hearing. So I'm going to give you an opportunity to take care of this today. You can either mitigate it, admit the violation, and ask for a reduction in the penalty, or set it for a contested hearing. Or if you believe you're going to be able to get insurance in a reasonable amount of time, we can set it for a hearing for you to come back and show proof of that. What would you like to do today?
I'd like to try to get insurance.
You want to try to get insurance? Are you looking at a DOC violation right now? Are you just looking at a 20 or 30 day?
I think it's less than that. It's my first violation.
It's your first violation?
Yes, sir.
So if we reset this for a mitigation hearing sometime in March, you'd be able to appear?
Yeah, we're good, yeah.
Do you know what you need to do in order to get your license reinstated?
Yes.
Okay. And you're going to take steps to do that?
Yes, sir.
All right. So let's reset this to a mitigation document sometime in the middle of March.
March 18th, Your Honor?
We'll set this for March 18th.
Okay.
Mr. Montalongo. No driving until you get your license reinstated, okay?
Okay.
In fact, I'm going to give you a copy of your driver's abstract that tells you the cases that are holding your license currently.
Thank you.
There's a time table in here that I just indicated those counts 1 and 2 are dismissed. We'll transfer that to another file. I was redoing all of Luis Brito Gutierrez, you just stand where you are, sir. Good morning. Sir, you're here today on a charge of driving while license suspended and a driver under 21 consuming alcohol or showing the effects of having consumed alcohol. Those are misdemeanors punishable by up to 90 days in jail and a $1,000 fine. There is no mandatory minimum sentence for such a conviction. Do you understand that?
Yes, sir.
I have reviewed the affidavit of probable cause, and I do find probable cause in this case. You do have a number of constitutional rights as a result of these charges. Were you able to hear and understand those rights as they were played before court was called?
Yes, sir.
All right. You had a chance to talk to Mr. Huey about this case as well. After talking with Mr. Huey, you've handed forward this statement of defendant on plea of guilty to the what's called a minor DUI. Did you review this statement with Mr. Huey?
Yes, sir.
Did he read it to you, or did you read it? And there are some initials on this document. Did you place these initials here?
Yes, sir.
And did you place those initials here to indicate that you understand the rights you have, you understand the potential consequences, as well as the potential immigration consequences for a plea today?
Yes, sir.
And there is a signature on this document as well. Did you place a signature on this document?
Yes, sir.
And did you do that to indicate that you understand the facts of this case? You've had a chance to discuss this with Mr. Huey, and you are entering this plea today voluntarily?
Yes, sir.
You understand the recommendation that's made is just that. It's a recommendation. I don't have to follow it. If you plead guilty, you do face up to 90 days in jail.
Yes, sir.
Other than this recommendation, has anybody made any promises or threats to get you to plead guilty today?
No, sir.
To count 2, the charge of a driver under the age of 21 consuming alcohol or marijuana, a crime which was committed on or about January 7th, 2021 in the city of Pasco. How do you plead, sir, guilty or not guilty? And your statement is that on or about that date in Pasco, Washington, I drove a car with a BAC greater than .02. Now, it needs to be just a little bit more than that. You're under the age of 21, is that correct?
Yes, sir.
I'm going to add that language to this form, okay?
Oh, did I miss something? It's probably my fault.
He's under the age of 21.
Okay, that's important. Sorry about that.
And with that additional language, I'll accept your plea of guilty and find a factual basis for the plea. I will dismiss count 1, the driving license suspended in the 3rd degree charge pursuant to the plea agreement. Mr. Brito Gutierrez, you do have a right to address the courts regarding this case before any sentence is imposed. Is there anything you would like to say?
Nothing really, just I messed up. I had already stopped drinking. And just, I don't know, just chose to drink. Pay the consequences for it.
You're a pretty young individual, Mr. Brito Gutierrez, and already have 2 or 3 alcohol-related violations on your record. I caution you, be careful. These can spiral out of control. I just saw a gentleman yesterday, number 5 DUIs. You know, these things have a way of turning south.
This is a good. That's a good.
On the, I'm going to accept the recommendation. I do have a couple of questions for you, Mr. Brito Gutierrez, regarding your work. Are you working currently?
Yes, sir.
What kind of work do you do?
Job working.
And do you support anybody besides yourself?
Just, I'm working at work right now.
All right. So you're contributing to your household there on behalf of your mom?
Yep.
90 days in jail with 89 days suspended. Credit for 1 day already served. A fine in the amount of $350, a $43 criminal conviction fee, and a $102.50 traffic penalty assessment. Actually, I'm going to adjust that slightly, a $250 penalty. You will be on probation for 2 years. During that time, you're not to have any criminal violations or incidents. There's a jail assessment of $50.
Are you going to charge him probation fee?
Yes, $200. Set payments at $25 a month in this case and begin those on February 8th. While on probation, you're not to drive without a license or insurance. You're not to have any alcohol-related infractions or offenses. You're not to use or possess any alcohol, marijuana, or non-prescribed drugs, or to have an evaluation within the next 120 days. attend the DUI Victims Impact Plan within 120 days. Mr. Malaga, are you still on the North Oregon Avenue address?
No, it's Campolina. Wait, was that me or her? Yeah, he's gotta be stuff.
Oh, I'm sorry, Mr. Rito Gutierrez, I'm sorry, Mr. Malaga. I was looking at two different files. Are you still on the North Oregon? Thank you. You are placed on probation. You will be required to meet with probation and follow their directives. Do you understand that, sir?
Yes.
And you did receive also an infraction for operating the vehicle without insurance, Mr. Brito Gutierrez. As in the other case, typically you would have to mail something in to request a hearing or just pay the amount of the penalty. Do you want to address that today? You can do it by requesting either a contested hearing or a mitigation hearing, or you can resolve it today with a mitigation hearing. If you believe you're going to be able to get your license and you're going to get insurance, I'd set it out to give you an opportunity to get your license and insurance and come back and show proof. All right. So let's reset the infraction to a mitigation docket. Let's go to March 18th as well on that. I'm going to give you a copy of your driver's abstract. I believe that's already been done. Give you a copy of the judgment and sentence. You are required to meet with probation at 2 o'clock on January 19th. That's a telephonic appointment, but it's as important as an in-person appointment. We treat it the same. A failure to appear could result in a warrant, so make sure you stay in touch, okay? Christopher Gibson.
Yeah.
Mr. Gibson, if you stand where you are, please. Good morning. You're here today on 2 charges, giving false information and a drug paraphernalia charge. Those, the giving false information is a gross misdemeanor. It's punishable by up to 364 days in jail and a $5,000 fine. The paraphernalia charge is a misdemeanor punishable by up to 90 days in jail. Do you understand that, sir?
Yeah.
You do have a number of constitutional rights as a result of this charge. Were you able to hear and understand those rights as they were played in the other room?
Yeah.
You've had a chance to talk to Mr. Huey today as well. After talking with him, you handed forward this statement of defendant on plea of guilty. Did you review this with him?
Yeah.
Did he read it to you or did you read it yourself?
Oh, yeah.
And there are some initials on this document. Did you place these initials here?
Yeah.
Did you place these initials here to indicate that you understand your rights, you understand the potential consequences as well as potential immigration consequences if you plead guilty?
Yeah.
Did you also sign this document?
Yeah.
Yes? And did you do that after discussing this case with Mr. Huey and to indicate that you understand the case and you're entering this plea today voluntarily?
Yeah.
Other than this recommendation, has anybody made any promises or threats to get you to plead guilty today? To the charge of giving false information to an officer, the crime was committed on about January 8th, 2021 in the city of Pasco. How do you plead, sir? Guilty or not guilty? Pardon me? You're pleading not guilty to that offense?
You pleading not to, you told me you want to plead guilty. Guilty.
And are you pleading guilty to the false information?
Yeah.
And are you pleading guilty because on that date you intentionally lied to the officer about your name during an investigation?
Yeah.
All right. I will accept your plea of guilty. If there's a factual basis for the plea, I'll dismiss the paraphernalia charge pursuant to the negotiations. Mr. Gibson, is there anything you would like to say regarding sentence in this case?
No.
You're not working, is that correct, Mr. Gibson?
Oh, yeah.
2 days in jail with no days suspended. There's no credit. That's a balance of 2 days to serve. The paraphernalia will be forfeit. I am dismissing count 2 pursuant to the plea negotiations. Mr. Gibson, I'm aware of your current situation. I understand that both not only do you not have a permanent address, you don't have any income. I'm going to find that you meet the statutory definition of indigence, and I'm not going to impose any fines or costs. That'll conclude your case today, Mr. Gibson. You can have a seat. Marcus Van Buster. Good morning. You are here today on a charge of simple assault. That is a gross misdemeanor. If convicted, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. Do you understand that? You do have a number of constitutional rights. Those rights were played before court started. Were you able to hear and understand those rights?
Yes, sir.
You have had a chance to talk to Mr. Huey today, and after doing so, you've indicated you wish to plead not guilty and request the court appoint an attorney. It appears you do qualify for court-appointed counsel. I will appoint an attorney to represent you. Your attorney's name is Mr. Scott. The probable cause has been found in this case. And are you still at the North 4th Avenue address?
Are you going to do the Yeah. We just need to appoint an attorney for him.
Conditions of release, gentlemen?
Yes, Your Honor. Mr. Van Busker was brought in on a $500 warrant, and he also has a warrant out of YDC court. I'm not familiar with which jurisdiction. That's Yakima. Okay. So he has a warrant out of Yakima, as well as a history of crimes for another case. So the city's gonna ask that $500, that bail on a $500 warrant remain in place. City's also gonna ask, aside from the standard conditions, just that
he would have they did not discuss the facts of the case with any alleged witnesses or victims.
Mr. Healy?
Yes, Your Honor, I did go through that warrant with him in Yakima. It looks like some kind of deferred other, or he may not be in compliance. I didn't look at the docket notes, but it might be because he's not paid his fine. So there's a $150 balance. And this might be an issue, I told him, of a new violation. But I read the PC statement. He was contacted at the time, and it appeared at the end that that the officer felt that it was resolved in a peaceful manner. I don't know the exact words. He indicates there's no injuries by either party. Seems like more mutual argument, and that he let them both go, and said it was resolved peacefully, if I'm not mistaken. He did not know anything about the arraignment court date. I think this was a mail summons. And I think the Yakima one, he did not know about that either. I would assume that the Yakima court also mails or summons on probation violation. And he indicates to take care of that Yakima warrant. So he's hoping to PR. He's been in the Tri-Cities for about a year and a half. He moved from Yakima to here. And he's currently working part-time at a department there. And he doesn't make a lot of money, but he will come back to court. He's hoping to PR.
Well, Mr. Van Buskirk, we sent you notice to your address for that hearing. You didn't show up. So what assurances do I have that if I release you and give you another court date, you're going to come back?
I haven't got any paperwork on it.
Well,
If I did, Your Honor.
Mr. Van, we sent it to the very address you just confirmed is your current address. As well as another address in West Richland, just to ensure that you received the notice.
Can I just say one thing, not the notice? I went to the blood bank in Fenwick to blood donation, and I had to take a piece of mail with me. I gave them a piece of mail that I had from here, and they never returned it to me. They still have it. I didn't know what it was. I figured that what the letter was. I will come back to court, I promise.
Well, don't make promises that you're not going to keep, because I'm looking at every criminal case except one from 1993 has had a warrant issued in it for you not appearing in court. I have reviewed the case in this matter, the facts of this. Even though you didn't appear, I'm going to give you an opportunity, Mr. Van Buskirk, given the current circumstances at the jail. I'm going to release you on the condition that you have no criminal violations. You contact your attorney and maintain contact with your attorney, that you make appointments with your attorney so that your attorney can assist you on this case. I will tell you, Mr. Van Buskirk, I will confirm with your attorney whether or not you're staying in touch. If you don't appear in the future and you're not staying in touch with your attorney, I could modify these conditions and place you back in jail until bail is posted. You understand that? Your next court date is February 1st, 2021 at 8:30 in the morning. You're not to discuss the facts of this case with the alleged victim or any other witnesses. You leave that to your attorney. Do you understand that?
Yes, Your Honor.
All right, we will provide you with these conditions of release as well as your attorney's contact information. That concludes your hearing. You can have a seat. Jose Madrigal. Mr. Madrigal, you're here today on a charge of destruction or removal of property, domestic violence, and simple assault. That's been amended to a domestic violence charge as well. Those are gross misdemeanors. If convicted of either one of them, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence, but a conviction for the simple assault domestic violence would result in the loss of your right to possess, own, or control a firearm unless your right is restored by a court of record. You understand that?
Yeah.
You do have a number of rights that were played in a video before court started. Were you able to hear and understand those rights?
Yes.
Do you have any questions about those rights?
No.
You have had a chance to talk to Mr. Huey today, and after talking to Mr. Huey, you've indicated you want to plead not guilty and you requested a court-appointed attorney. Is that correct?
Yes, Your Honor. That's good.
I will enter a plea of not guilty and will appoint Ms. Judy Chang to represent you. Is your, let me see here. Your current address is in Texada Lane, is that correct?
Yes.
Aaron, is that the same address as the alleged victim?
Yes, it is.
So as far as, I know we're gonna probably address the no contact order, I'll wait until after that.
All right.
As far as it.
Conditions of release.
Yes, Your Honor. I guess kind of on cue, the city is going to request a no contact order in the case. The victim did request one. And while Mr. Madrigal does not have very much history, the kind of alleged violence in this case of, I believe it was punching and trying to fight his stepfather, the city's going to just kind of act out the victim's concern and request that no contact order. With that in place, the city is okay with a PR and the other conditions, Your Honor, aside from the standard one. The city just asked that he have no new domestic incidents and that he not discuss the facts of the case with the alleged victims or witnesses.
Mr. Healy?
Yes, Your Honor, he is 30 years of age and he does indicate that he has mental health issues. He's had it for quite some time. He's been on Social Security disability for his mental health issues for at least, he thinks, 4 years. He gets about $600, a little over $600 a month. I did advise him that in the PC statement, the alleged victim did request a no contact order. He says that that's his father, that's where he lives. He has really no place to go, but if you are inclined to issue the no contact order, he will abide by it. He says he has a brother, right?
Yeah.
In town that he's gonna reach out to try to stay there. But right now, as far as address, if you do issue the no contact order, he does not know his brother's address at this time.
Right. Your Honor, that's my stepbrother.
Stepfather, I'm sorry.
The victim in this case, or the alleged victim, has asked for a no contact order based on this incident that took place on January, I'm not sure if it's the 6th or the 7th, but the report says the 6th, or the affidavit says the 6th. The citation says the 7th. But they also list him with a date of birth that would make him only 8 years old at the time that Mr. Madrigal was born, so.
Can we get a corrected date of birth, please, sir?
I believe that it may be 62 rather than 82. So I'm going to modify that on the protection order.
Thank you.
I just want to say,
No, don't say it. Don't say it. Unless you want to, don't actually, don't say anything.
Mr. Madrigal, there has been a request for a no contact order, so I'm going to issue the no contact order. It is a temporary order that will expire in 2 years on January 8th, 2023. Only the court can modify that no contact order. Under the terms of this order, you do not cause, attempt, or threaten to cause bodily injury to the protected person, Mr. Soto. Do not contact him directly, indirectly, in person, or through others, by telephone, by mail, or electronic means. That means by text or any other social media contact. You leave any contact with him up to your attorney. Do not knowingly enter, remain, or come within 500 feet of his house, his school, or any workplace, or his person. If you violate this order, you could be arrested because it is a criminal offense. You can be arrested even if the person protected by this order invites or allows you to violate the prohibitions. Do you understand that, sir?
Yes.
Do you have items at the house that you'll need to recover or pick up?
Yes, Your Honor.
And
I have clothes.
and you're going to reach out to your brother to assist you. Do you want me to authorize the Pasco Police Department to assist you as well?
Yeah.
For a civil standby, you can recover only necessities at that location. You understand that, sir?
Yeah.
We will provide you with your attorney's contact information. You are required to contact Ms. Chang. I'm going to release you on the condition that you have no criminal violations, you have no domestic violence related incidents, and you obey the no contact order. You understand that?
Yes, Your Honor.
When you come back to court, and your next court date is February 1st, you bring with you your current address. You understand that? All right, we have some paperwork for you, including your attorney's contact information. That concludes your case. You can have a seat.
Thank you.
You're welcome. Right, Miguel Carrillo Hinojosa. Good morning, Mr. Carrillo Hinojosa. You're here today on some probation violations, and also it looks like you had failed to appear on some matters that were not resolved yet. In fact, it looks like no arraignment had been addressed. We'll talk about the probation cases first. On cause number ending in 03, there's an allegation of failing to report, failing to comply with treatment, and having a new offense. I think that new offense is one of those pending charges. You're also here on cause number ending in 529. There's a violation report dated May 22nd with the same violations, other criminal charges. Also that your non-compliance with treatment, a report filed on October 20th and a subsequent report filed on July 14th, adding those other charges as well. You've indicated here, after talking to Mr. Huey, that you are admitting the violations. You understand that the recommendation on cause number ending in 503 is 5 days, and the recommendation on cause number ending in 529 is for 10 days. Is that correct? Pardon me?
I got
You understand that? And you are admitting those violations, is that correct? All right. Is there anything you would like to say about the recommended sentence, Mr. Carrillo?
Honestly, I don't think 14 days will help me now. I mean, I've been on quarantine for about 7-8 months now. I've been doing it correctly. I've been on the streets like before. I'm in a room 24/7. That's the reason why I missed a couple of days. Because my phone is stolen and I feel like I don't like having money, so I don't know those days. I don't think Sunday, Monday, Tuesday, what day, you know what I mean? I don't like days, I don't like on days, you know what I mean? So it's kind of hard, I'm never having that time. I've been getting the hang of it. I'm not doing drugs no more. For the most part, just trying to find out how to deal with my anger. And I don't see how it is frustrated. You know, that it's only gonna make it worse. That's my problem right now. I've been literally in the room for months now. For up to 16 hours a day, every day. Every day, I don't think it's obviously helping. I mean, it's not, I'm supposed to go sleep and I'm sure, I mean, honestly, you guys didn't need this place and come with that habits, man. I just got a dog. I'm like, I don't know some habits like this, you know what I mean?
Where are you working, Mr. Carrillo?
Working in a restaurant. He's just watching and stuff. Good job, man. Not a table, I'm there for it.
I didn't understand that last part you said. What did you say? After that, you said something else.
It's a dishwasher. You know, I mean, I'm just sitting, trying to just do my things good, and honestly, every time I'm doing, I'm trying to do the thing, you know what I mean? People come around me, and it's like, sometimes the reputation, everything is everything, sometimes everything, you know, but I'm an honest dude, I don't lie to people, I don't tell you what you want to hear, I tell you what it is, and everybody else, man, that I've been going through these problems with, is lying, and I got anger in me, you know, so that it's good being out there for the way people all the time, and rules that we got here, you know what I mean? And if they want to keep them out there, then they won't have problems, that's it, you know what I mean? And if I give them more time, well, I'll probably get the next more rules, I don't know, you know what I mean? So what's going on, you know?
Well, my experience with you, Mr. Carrillo and Jose, is that you are a person who says what's on your mind at the time, that you do speak plainly. I appreciate the comments you've made here today. I'm going to indicate today you have admitted these violations in each of the cases. I'm going to accept the recommendation. The only difference is I'm going to run them concurrently for a total of 10 days on these two cases. Made a lot of statements here today, Mr. Carrillo and Hinojosa, about wanting to change your life and move forward. You know, you have a lot of history, you know, and you have a lot of issues probably with regard to anger or something like that. And just in the last year or so, you know, you've been here 1, 2, 3, 4, 5, 6, 7 times.
Yeah, and there are just people fighting and fighting and stuff like that, you know what I mean? Family, my own family, girlfriend might be a little cheap.
Mr. Hinojosa,
I mean, they are just, I let my anger get to me, and I just feel like if you go for rule, or if you did this, then either, I mean, like, it's still kids. Oh, I'm here for some bullshit, and I got respected 4 times in my face, 5 times in my face. I've been to proper channels, I told every single person in the household that this man disrespected me in my face 5 times. I've been to every single person in the household, and his who disrespected me 5 times. They didn't do shit about it. I went to the next person, and he disrespected 5 times. I went to every single
I'm going to suggest something to you, Mr. Carrillo Hinojosa, that you might benefit from some programs that help you deal with ways to resolve the frustration rather than just physically acting out.
I'm not here for anything that couldn't help me. You know, I've been really trying to be. I don't care. I've been trying to good to me. Yeah, I need to go out. I got one stuff, but I got one. Otherwise, I wouldn't be going. I don't mind being or anything, but I just don't know if I'm ignorant to all the programs that are out there. people being locked up all day in my room and stuff, you know what I mean? I don't go anywhere. It's a mess.
And Mr. Correa and Jose, you are also here for some other matters. There's a trespass in the first degree, a theft, and also a destruction or removal of property and malicious mischief, domestic violence. Each of those are gross misdemeanors. If convicted of any one of them, you face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for any of these convictions, but on the domestic violence, if convicted, you would lose your right to possess, own, or control a firearm. You understand that, sir? You have had a chance to talk to Mr. Huey today. Did you understand those rights that were played before you came into the courtroom? After talking to Mr. Huey, you indicated you wish to plead not guilty to these offenses. I will enter a plea of not guilty on your behalf. We'll appoint Mr. Scott to represent you in each of these cases.
No, Your Honor, on case ending in 956, he has already Mr. Liver. Would you like us to reappoint Mr. Scott for that case as well?
On 956.
Yes, it is a destruction or removal of property and malicious harassment. It was the case calendared for his first appearance. Yes.
Yes, go ahead.
Appoint
Mr.
Scott.
Scott.
Okay. I will send him the information.
And in these cases, in cause number ending 736, bail is set in the amount of $1,000. On cause number ending in 008, bail is set at $500. On cause number ending in 956, bail is set in the amount of $2,000. Conditions of release.
City just asks that bail remain in place as well as the no contact order that looks like is in the DV case. And then just the standard conditions,
Mr. Hughes?
I talked to him about why he's in this court. I think he indicated to me that he just can't remember. He's had a lot of things going on in his life and he just can't remember. Do you want to address why you didn't show up in court on those cases?
I just don't remember. I don't keep track of my day. I'm responsible. I'm not going to do my day whenever I had phone with me. That's not affected. When I go to the room, once a week, I usually start to go back to the room. So I kind of get to check on my day like that. I can't be doing all that. You know what I mean? I'm in the room all day. Stay in the room all day. You know what I mean?
Be careful of your language, Mr.
Apologize. That's what it is. I mean, I stay in the room all day long. I don't appreciate that. I don't appreciate that. I don't know that.
Mr. Carrillo?
I apologize. But you know what I mean? Like, I get too that crap. I'm in the room all day. I don't try to day. I mean, sometimes you get so embarrassed that something happens. You want to forget about the day, you know what I mean? Or you go into high or whatever.
What's your current address, Mr. Carrillo?
I don't know.
You don't know?
I believe you said you didn't have one.
There is a history of failing to appear and a history of violating conditions of probation. On cause number ending in 736, under the current circumstances, I'll reduce the bail from $1,000 to $500, given his financial circumstances currently, as he's indicated. Post that bail, you make all your court appearances, you not have any criminal violations or incidents. You're to stay in touch with your attorney. We'll provide you with your attorney's contact information. If you don't stay in touch with your attorney, these conditions could be modified. Mr. Carrillo, do you understand that? On cause number ending in 956, set bail in the amount of $1,000. Continue these cases to January 25. not to have any criminal violations, domestic violence related incidents, and obey no contact orders currently in place. On cause number ending in 008, we bail at $500 as well. Mr. Bell, these are set rather on a short time frame, so I ask that you make sure you get discovery over to Mr. Scott. So you can leave Mr. I believe that concludes our cases this morning, other than the Zoom or remote hearing. Yes.
Where were those cases set, Judge?
January 25th.
Thank you.
Right. I think the last matter we have is the remote hearing. Let me get myself.
Do you want the docket for that remote?
I will grab a piece of paper and take notes.
Get logged in here. You're gonna have to allow me in.
Okay. I've sent a couple of messages just asking that the participant just to continue waiting. We will be with them shortly.
Join the video now, so go ahead and allow her into the courtroom as well. All right, good morning. Ms. Oglesby, can you hear me? We're having an issue. She's not quite connected yet. I can see you, Ms. Oglesby, but I don't think we have audio yet. There. Are you able to hear me? You are muted, so you'll have to unmute yourself so I can hear your comments. Can you send an unmute? There we go.
Okay.
All right, Ms. Oglesby, good morning, and thank you for your patience. We had a number of cases going on in the courtroom here today, as well as this one scheduled. It is now 10:55 in the morning. This is Pasco Municipal Court. Ms. Oglesby is here on a review of a stipulated order of continuance. She's appearing remotely today. In the courtroom, as well as myself and my clerk, is Mr. Rio and Mr. Bell on behalf of the city of Pasco.
Okay.
And just to outline things, Ms. Oglesby, I have reviewed the information that I have, which indicates you have paid the costs associated with this stipulated order of continuance. And I believe what Mr. Rio is probably waiting for is proof of compliance with the mental health requirement. If you recall, when this was entered on November 26, 2018, there were the condition that you pay the costs, not use any alcohol or marijuana or non-prescribed drugs, that you have no criminal violations, and that you continue or maintain with your mental health treatment. There is, I don't see any new criminal violations, and the costs have been paid, but the issue is the mental health treatment. Do you understand that, Ms. Oglesby?
Honestly, I see a mental health counselor now. Honestly, with what was going on 2 years ago, I don't remember what the requirement was, but I'm willing to do anything that's needed to be done.
Well, and that's why we give you all of these things in writing at the time, so you can make sure that you have a list of the requirements of the things that you agreed to at the time. When you entered the stipulated order of continuance in 2018, you agreed to pay the cost, you agreed to have no criminal violations, and you agreed to file with the prosecutor proof that you were attending your mental health treatment. And I think that's what Mr. Rio would be waiting to confirm. Mr. Rio indicates that's correct. So
okay.
I don't know if he is willing to do this. This was set for compliance on November 23rd of last year. You failed to appear at that hearing, and it was reset to January 11th, and then you requested a hearing to appear remotely, and it was scheduled for today's date. So I'm going to ask Mr. Rio if he would give you an opportunity to provide proof of having attended your mental health treatment. And I would suggest, if he does so, Ms. Oglesby, that you would have to provide proof that you have been attending since you started, whenever you started after that November date in 2018. Okay?
Okay.
Mr. Rio.
I am in agreement to give more time, since it sounds like she's been in compliance, or at least attempted to. So
all right.
give that chance, and if you want to sit in a month or two, I'm fine.
All right, Ms. Oglesby, in case you couldn't hear Mr. Rio, he's in agreement to reset this to give you an opportunity to show compliance with this, the stipulated order of continuance. The way you're going to have to show compliance is by providing to his office proof that you've been attending your mental health treatment, okay? So
okay.
You'll need a letter from your counselor that says
okay.
you're in compliance with treatment.
Okay.
He will give you another month and a half or 2 months to gather that information and present it. We can set this for another remote hearing. We'll want to set it on a Friday.
I don't think so, Judge. I think this could be on a Tuesday.
Okay. Or on a Wednesday.
Or Wednesday. I think usually we do these we have been doing them on Tuesday mornings.
Oh.
I don't mind if she's going to get it to me in advance. You know, I can tell her, hey, you don't need to be here, or you do. But I think if you want to give her my email address.
Yes.
which is just my first name, Michael, Michael, @bellbrownrio.com.
Ms. Oglesby?
Yes.
Do you have something with which to write?
Yeah, I have my notebook right here.
Okay. The information you have regarding your mental health treatment, you can email that to Mr. Rio at Michael, that's Michael, at, this is all one word, Bell Brown Rio. So it's BELLBROWNRIO.com.
Okay.
And what we're going to do is set this for a regular Tuesday morning docket let me get a calendar here. We'll set it on March 16th.
March 16th.
Now
Okay.
that's a regular hearing date. If you provide the information to Mr. Rio well in advance of that date so that he can review that, if he agrees with it, he'll strike that hearing. If he doesn't, he'll let us know, and we'll set this for another remote hearing for you to appear remotely. Okay?
Okay. So I'm going to get the letters from both of the counselors that I've been seeing, and I'll just email it to the address that you gave me.
Yes. And we still have a good email address for you and a good physical address? Are you still in Hayden, Idaho?
Yes.
On Ramsgate?
On Ramsgate, yes.
Ramsgate, okay.
Lane.
All right, and do we have her email address? All right, so, and we have the ability to contact you by email as well. So
Okay.
we will reset this to that date in March. And you get that information to Mr. Rio. And if he's satisfied, he will dismiss this. If not, we'll see you on, or if not, he'll let us know and we'll reset it for a remote hearing so we can see how we're going to proceed. Okay?
Okay, so will he email me back if he's satisfied with what I send him, or?
Yes, he will definitely communicate with you about that.
Okay, so so if he isn't satisfied, then I'll get information on the hearing for March 16th and a time?
Yes.
Okay. Okay.
All right. If there is nothing further, Mr. Rio and Ms. Oglesby, that concludes our hearing today, and you are excused.
All right, thank you.
All right, have a good day.
You too.